In this video, I'd like to give you a bit of background and context about how the law has traditionally applied to intermediaries in the offline world as well as the online world. Most of this background comes from the common law of torts. The law traditionally is comfortable imposing negative duties on people, but not positive duties. What this means is that it's comfortable setting prohibitions against harming someone, so do not commit murder, do not commit assault, etc. But it will not normally impose duties to affirmatively help somebody else when you've not had a role in causing the harm to that person. The law does not like to interfere with a person's free will by forcing them to come to the aid of another. This is commonly expressed as the rule that there is no general duty to come to the rescue of another person. There's also no general duty to control a person to prevent them from doing harm to a third party. Now, to tie this back to the regulation of internet intermediaries, it's interesting to ask, are we trying to prevent intermediaries like ISPs and websites and search engines from harming people? Or are we asking them to come to the rescue of someone who is being harmed by third parties? Sometimes the regulation of internet intermediaries looks suspiciously like we are asking them to play the role of the rescuer, and the legal basis for requiring this is not particularly strong. Now, at common law, there are some exceptions to the general rule that there is no duty to prevent harm occurring to the plaintiff. The first exception arises where the defendant is in a special relationship with the person who is doing the harm. These relationships are normally characterized by control on the one hand and vulnerability or dependence on the other. And the law recognizes only a very limited number of relationships that give rise to a special duty to control another person. Some examples of these relationships are the relationship between parents and children, between school authorities and students, and between prison wardens and prisoners. So you can see in all of those situations, there is significant control on one hand and vulnerability on the other, and the courts are more comfortable imposing a duty to control a person in those circumstances. The second exception to the general rule is where the defendant has had some role in creating or contributing to the creation of the risk from which the plaintiff needs rescuing. Then we can say that the defendant has actually had a causal role in bringing about the harm. They are not simply a bystander who is being asked to step in to prevent the harm. In the online context, plaintiffs will try to argue that the intermediary in question either had the requisite control over users or that they played a causal role in creating the harm or the risk of harm to the plaintiff. And on that basis, the intermediary ought to do something. It is appropriate to impose a duty on the intermediary to require them to act, to prevent or at least attempt to prevent the wrongdoing, and therefore to impose liability on them for failing to do so, for failing to act. You will see that nearly all arguments around intermediary liability, arguments saying that intermediaries ought to be liable, will fall within this framework of arguing that the intermediary either has sufficient control over users, that it's appropriate to require them to exercise that control, or that the intermediary actually had a causal role in bringing about the harm to the plaintiff. The difficult question, though, is deciding whether or not these claims are actually true. And what do they really mean? What does control look like online? And how much control over users is required to establish liability or required for us to reasonably say that the intermediary ought to act? What does an intermediary have had to have done for us to say that they contributed to the risk of harm, that they had a causal role in bringing about the harm? Is providing access to the internet enough? Is providing a sharing platform enough? What exactly must they do for us to impose a duty and for us to impose liability? What exactly is needed to make intermediaries liable? These are the questions that you will be exploring as you move through the content on intermediary regulation.